Welcome to Arizona Contractor License Center. The first thing to understand in your quest to become a licensed contractor is that it is a process. And as with any process, there are steps to follow. Missing or not completing a step properly may cost your business weeks or months in lost revenue waiting for license approval. Our job is to help you through every step of this process while preparing you for the test, processing the license application, and educating you on creating an environment for your business success. Chapter 1, Test Preparation. Our responsibility begins with making certain you get the right license for what you want to do and verifying that you have the experience and qualifications for the license. Once we have established the proper license, we will begin the process of preparing you for the test. All licenses require a business management test, and some licenses also require a trade test. The business management test may be waived if you already have an existing license in Arizona. The trade test, if required, may be waived with reciprocity from an approved state. We recommend that you prepare for and pass the business management test before preparing for your trade test. The business management preparation begins with an instructional presentation highlighting the key areas you will need to focus on. Once you have finished the presentation, we ask that you take a break, then begin reviewing the business management study material. While you are working through the study material, you will have access to a wealth of information and resources to guide you through the learning process. This includes an extensive reference library, math and trade instructional media, and personalized tutoring from any one of our customer service representatives. In working through the study material, we ask that you focus on learning and understanding, not memorizing. Our objective is for you to learn the information and be able to apply this knowledge in both your business and on the test. While working with our material, we do ask that you honor a few simple rules. Notes taken from our study material must stay in the office. Please do not write or mark in the study or reference books. You need to invest sufficient time into studying the material. Even though you feel that you have a general understanding of business and your trade, the tests are written by professional test writers who gather information from a variety of books and codes, which may not necessarily reflect the way you perform work in the field. With your years of experience in the field, you have learned many of these principles. This material will serve as a refresher course, but as you know, rules and laws are always subject to change. The amount of study time depends on your ability to comprehend the material. As with many things, the more you study, the better the results. Typically, 1 to 2 days is needed for each test. If you feel you need more time, there is no limitation on how long you may study. The state requires a passing grade of at least 70% on each test. The tests are scheduled and administered by a company contracted by the state of Arizona. You will need to contact the testing company either via their website or toll-free number to schedule your test. Please ask a customer service representative for this information. The tests are given on computers at all testing locations and will be in a question and multiple choice answer format. It is recommended that you schedule your test at least 2 weeks in advance. Taking a test may cause anxiety. However, you can relax because we offer a no-pass, no-pay guarantee. Should you not pass the test, we will work with you until you pass the test, or you may request a refund as long as you present the original test scores of your test to a customer service representative. Whether it is researching reference material or working one-on-one with you with the study material, we will spend as much time as necessary to get you through the test successfully. After you have passed the test, please bring in your original test scores to your customer service representative. At this point, even though you have passed the test, we would appreciate your feedback on the quality of your study material and how you felt you were treated throughout the process by our staff. Please repeat this process for both the business management and trade tests should both be required. This is the first step of becoming a licensed contractor. Chapter 2, Company Setup. Company Name. The second step will be to meet with your customer service representative to choose a company name that is recognized by the state of Arizona. Even though you may have used a company name for your business in the past, you may not legally hold the rights to that name. Names must be approved through the Registrar of Contractors Arizona Corporation Commission, and the Secretary of State. We will check your company name with all required state agencies to make sure the name is available. Company setup. Once your company name is approved by the state of Arizona, we will process your paperwork to establish your company as a legal entity. This could be a sole proprietorship, partnership, LLC, or corporation. I encourage you to steer away from a sole proprietorship or partnership due to exposure to risk. This will be covered in greater detail later in this presentation. Should time be of concern for the issuance of your license, it is important that you start this process immediately due to the many variables involved. The type of company you choose will determine how the process is completed. We encourage you to seek advice from an attorney or an accountant to answer any questions you may have about your company setup. This is your decision and your responsibility. If you do not have an attorney or an accountant, we can refer one. Choosing your company structure is one of the most important things you will do for your new business. There are too many legal threats and tax advantages available in the marketplace to take this lightly. Once you have decided on a business entity, we will prepare the necessary documentation and register your company with the appropriate state agencies. You may have to apply for business licenses required by the different municipalities. This will be your responsibility. The process of filing and approval for your company entity can take between 7 to 15 days after being submitted. Tax numbers. Your company will be required to obtain a federal employer identification number, also known as an EIN number. All entities within the state of Arizona must apply for a transaction privilege tax number, and if you plan on having employees, a withholding unemployment tax number. During the application process, we will apply for and acquire all of these numbers for your business entity. Chapter 3, Statutory Agent. The state of Arizona requires corporations and LLCs to declare a statutory agent. A statutory agent is an agent for your business who resides in the state of Arizona. This agent looks out for your entity's well-being. The statutory agent for the organization can file your corporate annual reports, receive all correspondence from the state agencies, receive court summons, receive legal notices and forwarding of mail, providing a consistency for your company that will help promote a healthy organization. Should your physical corporate address change, the statutory agent will notify all appropriate agencies of address changes. All of these, if not handled correctly, may end in the dissolution of your business entity and revocation of your contractor's license. As your statutory agent, Arizona Contractor License Center would be considered your company advocate. In addition to providing statutory agent services, we will answer or find the answer to questions you may have related to conducting corporate business within the state of Arizona. Chapter 4, Bonds. The state of Arizona requires all licensed contractors hold a license and tax bond on their company. The contractor may choose, in lieu of the bond, to self-fund a certificate of deposit equal to the bond amount, or pay premiums on the bonds underwritten by a surety company. If you choose to self-fund with a certificate of deposit, be aware these funds cannot be withdrawn for a period of 2 years after the close of the business, or the CD is replaced by a license bond. The bond amount is set by state statute according to the license classification and your yearly estimated gross income. Contractors may be exempt from a tax bond if they are able to demonstrate 2 years of good payment history with the Department of Revenue on a previous tax number. Underwriting requirements may vary depending on the license classification and/or the bond amount. Some bonds will be an instant issue bond, while others may require full financial disclosure and a credit check, which may result in delays in the licensing process. Our surety companies offer stability and competitive rates, and our bonding agents provide a depth of industry knowledge and consistency of customer service that would be difficult to find on the street. Chapter 5, Application Processing. Now that your business entity is filed and approved, and you have your passing test scores, you are ready to prepare your licensing application and file it with the Registrar of Contractors. Bear in mind that many contractors have locked up at this stage and lost valuable time in the issuance of their license. Whether it's a misplaced comma in your company name, incomplete work experience, or incomplete corporate officer information, the Registrar of Contractors will not hesitate to reject your license application. Having helped license thousands of Arizona contractors, our team of licensing specialists have a unique knowledge of the Registrar's licensing requirements and a proven system of checks and balances, giving you the confidence that the job will be done right the first time. Work experience forms must be completed by the qualifying party. A licensing specialist will review your completed work experience to ensure the Registrar of Contractors receives an accurate and sufficient work history. Inaccurate submission of your work experience may cause a substantial delay in the issuance of your license. Once your application has been submitted to the Registrar of Contractors for review, it may take up to 60 days to be issued. Your customer service representative will prepare and mail to you a packet of information that will include copies of all items submitted to the required agencies. When it is all said and done, you will need to allow for at least 2 to 3 months to prepare for and pass the test, set up your business entity, and apply for and receive your contractor license. And this is not factoring in major complications. Remember, bidding or commencing on a project before the actual issuance of the license is illegal. It should be noted, Arizona state law requires you to place your license number after the letters ROC on written bids, advertising letterhead, and other documents used in your business and be posted at all job sites. Fees. In working with Arizona Contractor License Center, there are 2 types of fees required to get your contractor license. One fee you pay to Arizona Contractor License Center to cover the cost of services we provide for you, and one fee you pay to the various agencies for the services they provide to you. Your customer service representative will provide you with a cost estimate breaking down all of the specific costs associated with the process. In general, the fees for Arizona Contractor License Center services include preparation for the business management test, preparation for the trade test, administrative fee for filing paperwork, premium for the license bond, and premium for the tax bond. The fees for non-Arizona Contractor License Center services include the business test and trade test, the Registrar of Contractors licensing fee, the Registrar of Contractors recovery fund fee, and the Department of Revenue transaction privilege tax fee. The total for these fees will vary based on the license you are pursuing. You can expect to invest anywhere between $1,500 to $3,500 to set up your contractor license. Should you have second thoughts and wish to complete the application process on your own, bear in mind that the majority of the fees will still apply, as well as the cost of your time and the mistakes you may make. You should feel fortunate to work in an industry where you are able to set up a business for this amount of money. When in doubt, consider the cost of establishing a restaurant or most any other business. Congratulations! Completing these steps will have secured your right to legally conduct business as a contractor in the state of Arizona. Chapter 6, Business Solutions. Neither holding a contractor license nor possessing the skills of the trade will protect you from the threats or will allow you to take advantage of the trends and opportunities involved in running a business. It is not the duty of the Registrar of Contractors to make certain you run a successful business. It's your responsibility. As you will see in the material covered in the Business Management Review, there are many factors involved in running a business, such as limiting your risk through commercial and personal lines of insurance, choosing your entity wisely to maximize your legal protection and limit your tax exposure, protecting the longevity of your company by responsible fiscal management, outsourcing your employer administration responsibilities, and finally, desiring to learn more about what it takes to run a contracting business. In order to focus on money-making activities with your business, you may want to look at employing the services of others for those jobs that require too much of your time and do not focus on finding your customers, selling your services, providing estimates that cover all of your costs, scheduling your work wisely, and completing and closing your jobs. There is an enormous amount of information available to help you run a successful operation. Arizona Contractor License Center can serve as your anchor in this search. Insurance, employer administration, accounting, and legal services are available through our referral network. If at all possible, choose firms that have experience working with contractors. This will increase your odds of an outside interest understanding your business. In addition, our website offers links to additional educational resources that may help you in operating a successful business. We recommend that you join an association or group of fellow contractors and participate in business seminars and share your desires with seasoned veterans. They are a wealth of information and experience. Our only wish is that you succeed in your contracting business. Please take advantage of all of the resources Arizona Contractor License Center has made available to you. If you have a question, we will either give you the answer or direct you to where you can find it. Our company is customer-driven. Please let us know what we can do to make this experience as beneficial as possible for you. The prospect of owning your own contracting business is an exciting and perhaps a fearful consideration. You are in a position to be in full control of your business, to succeed, and to build a company that will do more than just provide a paycheck. You are investing in a future success that will support your employees' livelihoods and perhaps become a family-owned business for future generations. There is no limit to your earnings. An unlicensed person is limited to a maximum of $1,000 per contract, and failure to limit the work to that amount can result in fines of up to $2,500 per violation. There are disadvantages of owning your own business. You will probably work more hours than you did when you were working for another company. You will be subject to various local, state, and federal government regulations. You will be responsible for your employees' actions. In short, the buck stops with you. You have to be the sales force, the accounting department, the quality control person, the training officer, the compliance department, the scheduling director, plus being a husband and family leader if you're a man. And if you're a lady, well, the list goes on and on. You get the picture. Owning your own business is very challenging and satisfying. You have unlimited possibilities to grow because of your unique abilities and ambitions. Due to the fact that you are watching this presentation means you have already made the choice to own your own business. One of the first things you will need to do is choose a company name. Chapter 7, Company. Every contracting company must have a name that is unique. That is, it must not be confusing and must not conflict with an existing name. The Secretary of State, the Arizona Corporation Commission, and the Registrar of Contractors each have a database of companies and trade names that are currently in use. These names cannot be used. The Secretary of State and the Registrar of Contractors suggest using a name that is descriptive for the business you conduct. Each state agency has different criteria that will determine whether a name is available for use. Because each agency can serve a different clientele, a name that may be available for use with one agency may not be available in another. A name must be available from all three agencies. In the state of Arizona, the license is issued to an entity, not an individual. The person that passes the state's required test, supplies verification of experience, and completes the application forms will be the qualifying party for the company's license. The license is attached to the company's entity, a sole proprietorship, partnership, corporation, or limited liability company. One of the first decisions is to decide what type of entity to operate your business under. There are several to choose from, each having advantages and disadvantages. You need to ask yourself several questions to help you decide which one will best meet your needs. Some questions to ask yourself are, who is going to make the business decisions in your company? Will you be the sole decision maker, or do you plan to allow others to make decisions? What risks are you willing to take? Are you willing to put your personal assets on the line? What regulations will you have to accept? Are you willing to complete annual forms and pay annual fees to remain a valid company? What are your future plans for your company? When your company has survived the ravages of time and you have a successful company, will one of your children want to purchase the company? Or will you want to sell the business as an established company with name recognition and an extensive client following? What are the tax considerations? Is there an entity that will allow you to pay less tax to the government? Let's take a quick look at several different entities and explore the pros and cons of each. Sole proprietorship. A sole proprietorship has the advantage of being the simplest and least expensive to set up. There are no filings to be approved by the state and no publishing requirements. As a sole proprietor, you alone make all of the decisions and have full control and responsibility for the company. The profits of the company are not taxed, but are passed on to the owner of the company as ordinary income. All income is subject to self-employment taxes, that is, Social Security and Medicare payments and regular income taxes. A disadvantage is if the company cannot pay its debts or if it is sued and a judgment is filed against the company. Not just the company's assets are at risk, all of your personal assets are subject to seizure. You cannot separate your personal assets from the company's liabilities. Ownership is not transferable, and the death of the owner results in termination of the company. General partnership. A general partnership is a legal association between two or more individuals. By pooling resources, a partnership has potential of greater financial capacity. As each partner has a financial rating, if each has a good credit rating, then securing a line of credit or a loan is much more likely. Partners are responsible to act in good faith for the company. In times of temporary illness, vacations, or absences, the other partners can make binding agreements to keep the company operating. The profits are not taxed at the company level, but are passed on to the partners and noted on each partner's W-2 form as ordinary income. Again, all of this income is subject to self-employment taxes and personal income taxes. The major disadvantage of this entity? A decision by one of the general partners is binding on all of the partners. As all partners in a general partnership can make binding agreements for the company, each partner has unlimited personal liability for all of the debts of this company. This means that each partner is personally liable for 100% of the company's debts, irregardless of the percent of ownership. A general partnership will be terminated by the death or withdrawal of any partner. Likewise, a partner cannot be added to the partnership. Limited partnership. A limited partnership is also a legal association between two or more individuals. A limited partnership requires at least one partner that agrees to provide the day-to-day management duties. This person is considered to be a general partner and will take an active role in the management of the company. This person then takes responsibility for the results of his or her decisions. Other partners that invest in the company but do not take an active management role are considered to be limited partners. In other words, they have no voice in the operations of the company, they are merely investors. As investors only, they have limited liability, losing only their investment if the company cannot meet its obligations, whereas the general partner shoulders the total liability personally. The profits are not taxed at the company level, but are passed on to the partners and noted on each partner's W-2 form as ordinary income. Again, all of this income is subject to self-employment taxes and income taxes. Corporation. A corporation is a unique business entity that essentially creates an artificial person. This person or corporation is separate from its owners, the stockholders. This creates a barrier from the liability of the corporation. Stockholders can lose their investment but are shielded from the liabilities that the corporation has incurred. This means the corporation can be sued or go bankrupt, but the stockholders are not subject to lawsuits for what the company did or did not do. This is called the corporate veil, and to penetrate this veil of protection, creditors must be able to prove fraud, such as the commingling of funds or other unlawful activities. A corporation may have as little as one stockholder, one director, and one officer, all being the same person. Ownership can be increased or decreased by the sale of either existing stock or the sale of non-issued stock. Directors and officers are not required to own shares of stock in the corporation. This will allow a corporation to hire talent without having to give or sell away ownership. The corporation will continue to exist as an entity even if one or more of its stockholders dies. This is a definite advantage of the corporation. However, corporations are regulated. Bylaws are required. Reports such as the annual report and certificate of disclosure must be filed annually and fees must be paid. Minutes of stockholders and directors' meetings are required to be kept and available for review. Special meeting minutes are likewise to be kept. The profit of the corporation generated during the year is subject to corporate taxes. The percentage of taxation depends upon the dollar amount of pre-tax net profit. After corporate taxes are paid, the remainder of the profit is distributed to the shareholders as dividends. The shareholders are taxed as individuals on the dividends they receive, hence the double taxation disadvantage. However, an advantage is there is no self-employment taxes on the dividends issued to the stockholder. Self-employment taxes include Social Security and Medicare taxes for both the employee and the company's matching payments. If you set up a corporation in Arizona to engage in business in Arizona, your corporation is known as a domestic corporation. If you set up a corporation in a state other than Arizona and you wish to transact business in Arizona using that corporation, you will need to apply for authority to transact business through that corporation. The corporation would now be recognized as a foreign corporation in Arizona. The Arizona Corporation Commission is the state entity that issues the Certificate of Incorporation. For priority service, an expediting fee of $35 per document is available. We recommend spending the extra $35 to expedite the application. After the application for your corporation has been approved, it is necessary to publish the Articles of Incorporation in an approved newspaper in the county where your company is located. It must be published in 3 consecutive printings within 60 days of the filing of the Articles of Incorporation. An affidavit of publishing from the newspaper stating the publication has been completed must be received by the Arizona Corporation Commission within 30 days of the last publishing date, but no later than 90 days of the date of the initial filing. Failure to do so can result in the dissolution of the corporation. At times, a corporation may want to reserve a name for future use or to keep others from using it. This can be done by registering the trade name at the Arizona Secretary of State. An application and a fee of $10 will reserve the name for 5 years. If you have a logo or identifying statement that you wish to protect, you can make application again at the Arizona Secretary of State and for $15 protect the usage of that trademark for 10 years. Subchapter S Corporation. The IRS allows privately held corporations through the use of Form 2553 to elect a Subchapter S Corporation status. The stockholders still enjoy all of the advantages of a C corporation, but the corporate tax is eliminated, removing the burden of double taxation. The limitations are: none of the stockholders may be non-resident aliens. All stockholders must agree to the Sub-S election. Only individuals may own stock, which excludes other corporations or LLCs from stock ownership. The subchapter corporation may be owned entirely by one stockholder and up to a maximum of 35 stockholders. Ownership can be transferred or added to, as with the C corporation, as long as the ownership adheres to the Subchapter S regulations. One advantage of both a C Corp and an S Corp is that Social Security and Medicare taxes do not apply to dividends. Therefore, the company is not required to withhold 6.2% for Social Security and 1.45% for Medicare taxes, nor is the company required to match that amount, saving you approximately 15% in taxes on your dividend payment over a sole proprietorship, partnership, or a one-owner limited liability company. Of course, you are still liable for personal income taxes on the dollar amount of dividends you receive. Limited liability company. A limited liability company is created by filing Articles of Organization with the Arizona Corporation Commission. The Articles of Organization must be published in an approved newspaper for 3 consecutive circulations and an affidavit of publishing sent to the Arizona Corporation Commission. The filing and publishing schedule for the LLC is the same as the corporation. The state does not require annual reports and fees for LLC to remain legal, but the operating agreement should be completed that outlines how the company will operate. This may require the services of law firm. A limited liability company has the advantage of being taxed as a sole proprietorship, partnership, or S corporation, and enjoys the protections of a corporation. One person may be the sole member and or sole manager in an LLC. Its members, managers, and employees are generally not liable for the debts and obligations of the company. Even though an LLC is not subject to double taxation as with a corporation, an LLC that has only one member is subject to Social Security and Medicare taxes on the total amount of the distribution of earnings. The cost of setting up an LLC is similar to that of a corporation, and all profits generated out of the entity are treated as individual earnings and divided among the members. A joint venture is created when two or more licensed contractors join forces for a single project. The contractors maintain their individual entity status, such as a sole proprietorship, corporation, or LLC, but combine their abilities to increase bonding limits, buying power, and manpower. This allows smaller companies to combine forces to compete for some of the bigger, more lucrative projects that would otherwise be out of reach. This session is not to tell you what type of entity is best for your particular company, but to acquaint you with some of the advantages and drawbacks of each type. We suggest you consult with a legal expert, such as an accountant and a lawyer, before choosing the type of entity you wish to form. Chapter 8, Bonds. First, let's discuss the differences between bonds and insurance. As an example, in the state of Arizona, you must have insurance on your vehicle. If you are at fault in an accident, your insurance company will have to repair the damaged vehicle and perhaps pay medical expenses for injuries incurred, plus money for pain and suffering. The insurance company does not require you to reimburse them for their losses. Insurance protects you, in this case, the contractor. Now, if you build a building and it is not to code, workmanship standards, or doesn't adhere to the plans and specifications, and you refuse to bring it into compliance, your client can place a claim against the bond. The surety company will have to hire another contractor to bring the project into compliance. When you applied for the license bond, you were required to sign an indemnity agreement that states you hold the surety company harmless, meaning they will not suffer a loss because you agree to reimburse them for their losses. They pay out, you pay them back. That's the agreement. The bond protects the owner, not the contractor. License bond. The state of Arizona requires all contracting firms to have a valid contractor license bond or a cash deposit on file at the Registrar of Contractors. These bonds or deposits will have a dollar amount that is the maximum amount the surety company can be required to pay for a valid claim. This amount is determined by the Registrar of Contractors. Factors that enter into the equation are the license classification that the bond is for, if it is a commercial or residential classification, and the expected annual revenue of the contracting company. The license bond or cash deposit can have a claim placed upon it for up to 2 years after the termination of the license. TPT bond. The company will also be required to purchase a transaction privilege tax bond. This bond is to ensure that the taxes owed to the Arizona Department of Revenue will be paid. If the taxes are not paid, the department can bring claim against the bond, forcing the surety company to pay up to the amount of the bond. The surety company will then turn to the individual that signed the indemnity agreement to repay them for their losses. Specialty contractors must have a minimum of a $2,000 bond, and a general residential contractor shall have a minimum of a $7,000 bond. Other classifications of licenses can require a bond of up to $102,000. Project bonds. There are several other types of bonds that are important in the contracting arena but are not required for the issuance of a contracting license. These include bid, performance, and payment bonds. These bonds are referred to as project bonds, as they may or may not be required by the owner of the project. A bid bond is simply a guarantee that the bidder will enter into a contract for the bid amount tendered. If the contractor refuses to do so, the bid bond is used to cover the difference between the bid and the next lowest bidder. A performance bond guarantees to the owner that the project will be completed according to the plans and specifications and any other requirement in the contract. If the contractor is unwilling or unable to complete the project, the responsibility of completing the project falls upon the surety to the extent of the performance bond amount. A payment bond protects the owner against any claims of unpaid materials or labor that may arise. This bond is primarily used when doing public property projects, such as federal buildings, jails, and courthouses. Liens are not enforceable on public property projects. To protect contractors that supply materials and labor on such projects, the Miller Act was passed into law. It requires performance and payment bonds on any public property project valued at a contract amount of more than $100,000. If payment for goods and services is not paid within 90 days after the last date of providing materials and labor to the project, a contractor or a material supplier can file against the bond. Claimants must bring suit against Miller Act bonds within 1 year after the last date of performing labor or supplying materials. Release of lien bond. If a lien has been placed against the title of the land that the building is built on for unpaid claims, the owner may purchase a bond called a release of lien bond, which will allow the transfer of land while the claim is being settled. This gives both the claimant and the owner time to settle the issues that lead up to the lien action and removes the hindrances to the transfer of title. Potential claimants have a time frame of 6 months after the owner purchases this bond to bring action against the owner. Chapter 9, Insurance. Insurance is one of those things that new contractors resist, often to their own peril. How many companies do you know that have been in business for a long time that are not properly covered by insurance? Contracting can be a risky business. A single incident can wipe out years of hard work. It doesn't even have to be your fault. Natural disasters such as hurricanes, tornado, floods, even lightning-caused fires can result in monumental losses. A moment's carelessness from one employee can reduce a nearly completed project to ashes. Who hasn't heard of a plumber or welder being blamed for a construction fire? These occurrences are called risks. You need to identify the types of risks that your company may incur and then take steps to shift the liability of those risks by protecting yourself with insurance. Enlisting the help of an insurance agent that has experience in the construction field will help you secure the proper coverage without paying for unneeded coverage. The state of Arizona does not require that a contractor have liability insurance. The only insurance that the state requires is worker compensation insurance if you have one or more employees. The state does not require that you have workers' compensation insurance on yourself nor on your family members. Workers' compensation is a medical insurance for injuries or deaths that have occurred on the job. The premiums for workers' compensation insurance are paid entirely by the company, never by the employees. In fact, if a company is found to be deducting funds from an employee's wages, the state can enforce fines. The premiums are based on the classification of the work that each employee performs and the amount of payroll for each classification. In addition, the employer's history of accidents and injuries, as well as the severity of them, also comes into the equation. A wise employer will emphasize safety, require tailgate meetings, and perhaps require drug screening to keep premiums affordable. General liability insurance protects claims against injury of people not employed by the contractor or a liability arising from the contractor's or subcontractor's actions. It will also protect against claims for damage to property belonging to someone else besides the insured. A prime contractor will most generally require that all subcontractors have general liability insurance and workers' compensation insurance in place prior to their commencing a project. If a subcontractor does not have these insurances and an accident happens, the prime contractor's insurance will be responsible for the damages. The general contractor has the responsibility to ensure that adequate insurance coverage is in place to cover the risks of the project. To protect your company, never rely on verbal comments that the contractor has adequate insurance coverage. Require the contractor or subcontractor to provide certificates of insurance or workers' compensation coverage prior to commencing the project. These certificates should come directly from the carriers providing such coverage. A builder's risk insurance policy provides coverage for the completed part of the project as well as the fixtures and equipment installed or stored on the site. Chapter 10, Employer Obligations. Hiring. There are many laws, both federal and state, that stipulate the way you conduct your business. When you employ people, certain guidelines must be followed when hiring. The company must provide certain working conditions, and even when terminating employment, it must be based on legal principles. A thorough knowledge of the rules and regulations are beneficial when conducting your business. First, when hiring, you must not be discriminatory. The Americans with Disability Act prohibits discriminating against qualified people that have disabilities because of their disabilities. This applies to all employers who have 15 or more employees. When the applicant demonstrates the skills, experience, and other requirements of the job, an employer cannot discriminate because of a disability. In addition, you are required to accommodate access and working environments, such as having a handicap-accessible restroom or a wheelchair height desk. You are not, however, required to provide accommodations that would negatively impact your business, such as a large expense to install an elevator. Next, you must pay your employees appropriately. The Fair Labor Act establishes the minimum wage, overtime wages, and record-keeping requirements, and child labor standards. These records may be reviewed by the Department of Labor. The minimum federal wage at this time is $5.15 an hour, but is expected to be increased. The states may designate their own state minimum wage, but the federal wage is $5.15. The Act also states that hours worked in excess of 40 during a work week are paid at 1 1/2 times the regular hourly rate. A work week is considered 168 consecutive hours. A federal act known as the Davis-Bacon Act requires any employer working on a federal job or a federally subsidized project pay their employees the prevailing wage as determined by the federal agency. Child labor law. The child labor law is designed to prohibit minors from working excessive hours in hazardous working conditions and interfering with school hours. The law basically states that children between the ages of 14 to 16 may work in non-hazardous areas that do not interfere with their school hours and do not jeopardize their health or well-being. Never put a child in a hazardous work situation. You don't want to live with the knowledge that you are responsible for a youngster losing a hand, finger, or an eye. Children age 16 and older may work unlimited hours, but not in a hazardous work environment. Employees age 18 and older may work unlimited hours and in areas deemed hazardous. Immigration and naturalization. Federal law prohibits employers from hiring illegal aliens. The law requires all applicants to present documentation of their citizenship or legal alien status. A Form I-9 must be completed on every employee within 3 days of hire. An employer cannot request that an applicant for hire submit a specific document, such as asking a person for a green card, as this may indicate discrimination. On the back of the I-9 form, there is a list of documents accepted as proof of identity and employment eligibility. Any combination of the listed documents is to be accepted as proof of eligibility. A good faith effort is required to ascertain that the person being considered matches the documentation presented. You cannot discriminate against a person that is a registered alien. All I-9 forms must be retained for a minimum of 3 years, even if the employee works for only a short period of time. Every new hire must be reported to the Arizona New Hire Reporting Center within 20 days of their being hired. This is to notify the state of Arizona of workers that may have child support responsibilities. The legislature instituted the wage garnishment law that governs how much can be deducted from a paycheck, typically 15 to 25%, to pay back a debt. Child support and taxes owed are not included in this maximum amount. W-4 form. When employees are hired, they must complete a W-4 form. This form records the name, address, social security number, marital status, pay period frequency, and allows them to choose the number of allowances they wish to claim. This form is then used to determine the amount of federal income taxes to be withheld from their wages. Once the taxes have been withheld, they must be paid to the federal government using Form 941. That records the total amount of taxes withheld during a payroll period. A-4 form. The state of Arizona has a state income tax. Each employee within 5 days of employment must complete an A-4 form that contains their name, address, social security number, and a choice of the percent of taxes to be withheld from their gross wages. The minimum required withholding percent depends on the annual compensation. If an employee's annual compensation will be less than $15,000, they can choose a state withholding of no less than 10% of the federal income tax withheld. If their annual compensation will be greater than $15,000, the minimum withholding percent shall be at least 18% of the federal income tax withheld. The withheld state income taxes must be paid quarterly if the total amount is less than $1,500. The form that must accompany the payment is Arizona State Form A1-WP. Failure to withhold or to pay the withheld taxes can result in a Class 4 felony. Each year, the employer must file an annual report form A1R to report to the Arizona Department of Revenue the total wages and total withholding taxes of all employees by February 28th. W-2 form. By January 31st of each year, the employer must give to each employee a summary of wages made and taxes paid. This is accomplished by giving each employee 3 copies of Federal Form W-2. If mailed, it must be postmarked by January 31st. If an employee quits or is terminated and requests a W-2 form, it must be sent within 30 days of the request. Unemployment compensation. Unemployment compensation is available to those individuals that have lost their jobs through a layoff or other reason not connected to their job performance. The employer is responsible for contributions into the Unemployment Compensation Fund. Every year, the employer will pay a tax on the first $7,000 of each employee's wages. Once that $7,000 of earnings has been achieved, the employer has met the obligation. The percent of that $7,000 is variable, depending on the amount of payouts recorded for the employer. A new contractor is assigned a beginning percent of 2.7%, but it can increase or decrease because of their unemployment compensation payout history. The employer uses the Unemployment Tax and Wage Report Form UC-018 to pay taxes greater than $100 quarterly to the Arizona Department of Economic Security. Failure to comply with requirements of paying unemployment compensation payments can result in the Registrar of Contractors revoking the license and imposing a civil penalty of $500. The employer must also pay federal unemployment compensation taxes that is 0.08%. This must be submitted using the 940 form. Untimely payments can cause an increase of the payment up to 6.2%. Social Security. A deduction from the employee's paycheck is their contribution to the Social Security Administration. The employer must withhold 6.2% of the employee's earnings. In addition, the employer must match that amount and submit both amounts to the federal government. There is a maximum contribution that changes each year. The collected funds, along with the employer's matching funds, shall be deposited quarterly and reported to the IRS using Form 941. The frequency of deposits will vary according to the amount of funds to be deposited. Medicare. Likewise, the employee must contribute 1.45% of their income and the employer must match it. The total amount will be reported on the Federal Insurance Contributions Act, Form 941, and be deposited quarterly. Chapter 11, Estimating. Prior to estimating. If you are asked to bid on a certain project, you probably received an invitation to bid document that describes the project and outlines the procedures for bidding. The specific rules for assembling and submitting the bid is contained in a document called the Instructions to Bidders. This document instructs the bidder of what to include, what to exclude, how and when to present the bid, and specific instructions on the sequence of the breakdown of items to standardize the bids to be evaluated. Be sure to read this document carefully so as not to be eliminated on a technicality. Careful estimating is necessary for an accurate bid. You must consider the cost of material, labor, equipment, subcontractors, overhead, and of course, profit. But before you start estimating, first consider these points. Is the project scope similar with your past jobs? You've been installing manufactured residential cabinets, and this project requires custom cabinetry for a bank. Is the project size similar with past work? You typically paint houses, and this is a hospital. Is the project duration similar to what you have completed? You build residential houses, and this is a shopping center. A house can be completed in 4 months, but a shopping center could take 9 months. Do you have the proper cash flow? Will you be able to meet payroll for several weeks until a progress payment comes in? If you are comfortable with your answers and feel confident in the project, take the time to review the project in detail before committing to an estimate. First of all, read the plans, specifications, general conditions. The plans contain the physical descriptions of the project to be constructed. The specifications designate the exact materials to be installed. The general conditions dictate the roles and responsibilities for the major players that will be represented on the project. Look for time restraints that could result in this project conflicting with other previously scheduled projects. Are bonding insurance requirements obtainable? Are required personnel available, and is special training needed? Is there specific equipment required, and is it readily available? Secondly, visit the project site. Check the topography, including soil conditions, trees, rocks, and ravines. Determine ease of access, turnaround areas, clearance and storage or staging areas. Survey the location for theft potential, location of utilities, and traffic control requirements. Be certain to make notes, record video, and take plenty of photos. Estimating. Of the several methods of estimating, the detailed survey, the unit price, and the conceptual are the primary methods used. The detailed survey method of estimating involves listing all materials and labor, known as a quantity survey, for a project with a specific price for each item. It is quite comprehensive and tends to be the most accurate. It also involves a great deal of time to do this type of estimate. The unit price method has a specific dollar assigned to a common unit, whether it is a square foot, linear foot, electric outlet, window size, etc. The estimate is then calculated on the amount of units to be included in the project. This allows for changes in quantity of units during the project, as each unit has a specific dollar amount. The conceptual method is generally calculated by the architect or engineer to give the owner a general idea of the cost of a project. This type of estimate is the least likely to be accurate. When doing the estimate, it is generally broken down into direct cost and indirect cost. Direct costs are the actual cost of material and labor, including the payroll burden of actually building the project. If some of the work is to be subcontracted out, add this contract amount onto your direct cost estimate. This constitutes the direct cost of the project. Indirect costs can be broken down into two categories: project overhead and general administrative overhead. Project overhead are the costs that occur on the project but do not fall under the direct cost classification. The project overhead would be considered all items used on the project but not part of the physical building. These costs can include the site's superintendent's wages and the payroll burden on those wages, job trailer rental, project phone, toilet facilities, water, first aid kits, project permits and fees, flagmen, barricades, project signs, cleanup costs, construction fences, etc. It might be called project support infrastructure, but not actual building items. Company overhead, also called general and administrative overhead, covers all of the expenses incurred to operate the company, such as staff salaries, secretaries' wages, office equipment, insurance, office telephone charges, and office rent or lease payments, items that cannot be charged to the project cost. The total dollar amount of the direct cost, project overhead cost, and company overhead cost forms the basis of the cost estimate. Allowances, which are a dollar amount allocated for special or personal preference items such as electrical or plumbing fixtures, carpet and floor coverings, must be noted. Contingencies will provide for unknowns such as soil conditions, weather, and special circumstances. Don't forget any taxes that may be applicable. Last, but certainly not least, determine what amount of profit needs to be incorporated into the bid estimate. The estimate is now ready to be printed as a formal proposal. Prior to the presentation of the bid, the owner or architect may wish to change or amend the plans or specifications. These changes are known as an addendum, or several are known as addenda to the bid. Addenda are issued before the date the bid is accepted. Once issued, the addenda become part of the contract documents. Chapter 12, Contracts. A verbal or oral contract, although legal, is difficult to enforce as it depends on what was understood and what the parties agreed to. Although the parties agree to what was said, the actual perception of what was understood may be completely different. In view of those difficulties, a written contract is an essential element in today's construction world. It assigns the rights and obligations between the owner and the contractor. The contract is interpreted exactly as written, not what was understood. To be valid, a written contract must include an offer, consideration, and acceptance. An offer is what you will do, such as installing a patio for $1,000. The consideration is what each party of the contract will receive. The contractor offers to build a patio for $1,000, and the homeowner pays $1,000 for a patio to be built, which is the consideration, and the acceptance is the signature on the bottom of the contract. If a contractor states they can give the owner a great price on building a patio, this is considered to be a negotiation, not to be confused with an offer which states a firm dollar amount. All parties of the contract must be of legal age, mentally competent, and have the authority to enter into a contract. A few legal guidelines have evolved over the years, such as written agreements will prevail over oral agreements. Later agreements will prevail over earlier agreements. Special clauses will prevail over general clauses. Handwritten agreements will prevail over printed agreements. Specifications will prevail over drawings. Words will prevail over numbers. The author or issuer of the contract has the responsibility to word the contract so that the requirements are easily understood. If wording of the contract is conflicting or is confusing and the issue is litigated to court, the ambiguous conflicts in a contract will be ruled against the party that drafted the contract. Most contracts contain an integration clause, wording that states only those items contained in the contract will be enforced. This eliminates verbal comments and memos that may be taken as contract changes. Owners have the right to inform the prime contractor of issues that may arise during the project or preferences to be adhered to and expect the prime to enforce them. This can be accomplished by the flow-down clause method. The prime contractor inserts wordage in the subcontract that states that the contractual obligations placed upon the general contractor flows down to all subcontractors. An example of this is when the project owner has to vacate a present facility with advance notice to the building owner, and he plans to occupy his new building on a certain date. He may require that the prime contractor notify him a minimum of 45 days prior to the scheduled completion date, or of any delays in the construction that may prohibit his occupying the new facility. This requirement flows down to all of his subcontractors, so if the electrician is contacted by his electrical supplier that certain electrical items are on back order, which will likely cause a construction delay, he must notify the prime contractor of the likely delay. This is known as a flow-down clause. To eliminate confusion about the terminology of a contract and a subcontract, an easy way to differentiate is to determine who is paying who. In a contract, the owner pays the contractor, who is now known as a prime contractor. If a prime contractor pays another contractor, they have an agreement known as a subcontract. Modifications to the contract. Once the contract has been signed, any changes are known as modifications. Modifications include clarifications, interpretations, and change orders. All modifications should be done in writing. Just as addenda are changes that happen prior to bidding, change orders are changes that are requested and approved after the contract has been awarded. Any change to the plans or specifications should be recognized by the use of a change order. The change order is typically issued by the project manager and must be signed by the owner or their authorized representative and by the contractor. It contains the description of work to be done, the change in the contract dollar amount, and any projected changes in the completion date. The change order eliminates squabbles at the payment portion of the contractual agreement and should be written and signed prior to the start of work described in the change order. Allowing changes to accumulate until the completion of the project weakens the contractor's chance of receiving full reimbursement of the changes. During the construction of a project, problems may arise that may not be addressed in the contract and must be handled quickly. A request by a contractor for a time extension or for an additional payment that has not been covered by a change order is called a contractor's claim request. This can occur if the owner does not make a decision that results in lost time or if code changes results in additional costs to comply with the new code. A clause is usually included in the contract addressing this issue. Types of contracts. There are many and varied types of contracts. A lump sum contract is when the contractor commits to do a specified amount of work for a specified amount of money. The lump sum contract is also known as a fixed price contract. is advantageous to owners who do not want to be faced with extra charges for unforeseen cost. Because contractors take greater risk with the lump sum contract, they also stand to make greater profit if the project was bid correctly and job site conditions are smooth. If the project was badly estimated and improperly bid, the contractor may be unable to complete the project. A design-build contract is when the owner assigns the design phase and the building phase to one company or entity. This company then will design the project and build it. This eliminates any finger-pointing of who is responsible for any problems that may arise during the project. A turnkey construction contract is similar to the design-build contract, except the contractor develops the entire project, from acquiring the land, procurement of the plans, overcoming zoning requirements, building the project, and obtaining the financing. A cost-plus contract simply states that the owner will pay for all costs related to the project plus a designated amount of profit. This contract reduces the risk of poor estimating and scheduling, but there is no incentive for a contractor to watch cost or to seek new or more efficient cost-cutting methods. As new products and methods are always forthcoming, contractors often discover better ways of accomplishing the same end result. As an incentive to save money, often a value engineering clause is included in the contract that rewards both the owner and the contractor when a cost-cutting method or product can be included in the construction. This clause normally allows the contractor to be awarded half of the savings. The unit price contract is when a project is estimated by the unit price method. This method is used when the number of units is not known or is subject to change. Each unit has its price, but the final total project cost is open. For example, a project site has unsuitable soil, but the exact depth and width is not noted. A contractor may excavate and remove an amount of soil at the discretion of the engineer and may charge by the cubic yard for removal at one price per cubic yard, and import suitable soil, spread, water, and compact the replacement soil at a different price. Another contractual term is the phased or fast-track construction. When time is of the essence and the design phase overlaps the construction phase, it is known as phased or fast-track construction. The practice of starting a phase of construction, even though the entire project has not been completely designed, is common. In this type of construction, each phase is bid and contracted separately, so the total project cost may not be known until the project is nearly completed. Progress payments. As construction projects can take months to complete, contractors receive partial payments during the project construction period. These are known as progress payments. These may be based on time or on completion or percentage of completion of certain tasks. The architect or engineer may be required to verify and certify the accuracy of the payment request. The progress payment may be reduced by withholding a portion of the prime contractor's payment to ensure all portions of the project are completed as required. This is known as retention, and it is usually withheld from the first draw or progress payment through the last draw. The retainage percentage may vary, but 10% is very common. This would mean that each progress payment request would be reduced by 10%. The release of retainage money is most often the final payment after all progress payments have been made. General conditions. The general conditions is typically an exhibit included in the contract. The contract specifies what the project is, the agreed upon amount, and the name of the contractor and owner. The general conditions dictate the rights and obligations of the owner, the contractor, the architect or engineer, and others that may be included in the contract. It is essentially the guidelines of who does what. It may also limit the responsibilities of the major players on the project. An example of this would be that only the prime contractor, the party that has a contractual relationship with the subcontractors, may direct the subcontractors. It may also include solutions to situations that may arise on the project, such as who is permitted to authorize change orders, use of alternative methods of materials, and verify progress payment percentages. On any project, the person responsible for the overall construction is the general contractor. General conditions are specific to a particular project and can vary, so read and understand the general conditions completely. If a dispute between the owner and the contractor arises, the construction contract usually requires one party to inform the other party of the dispute in writing. Typically, the owner and the contractor will sit down to work out an agreeable solution. If that is not possible, the issue will be moved to the architect. If the architect's decision is not satisfactory to either party, then it must go to arbitration or litigation. Chapter 13, Beginning the Project. Project planning and scheduling are essential for a smooth-flowing project. Project planning analyzes all tasks that must be performed, and scheduling addresses the sequence of events that must be followed to minimize the different trades from interfering with each other. The benefits of good planning results in better inventory control, reduces total project time, and increases the awareness of the specific time requirements. To accomplish this, the use of a Gantt or bar chart may be used for relatively small projects. It shows the scheduling sequence and the start and stop times for the individual tasks that make up the project. This method does have a drawback, as it does not show how the tasks relate to each other and the effective delay of one task on the entire project. For a more comprehensive scheduling document, a critical path method, called a CPM, is recommended. The CPM produces a diagram which depicts the longest continuous sequence of activities in the project. The critical path determines the overall amount of time that is required to complete the project. Other lines in the CPM represent activities that can be assigned to longer time slots that are no longer than the actual time needed to perform the task. It also reflects what activities must be completed prior to the commencement of another phase of construction. The CPM provides a bigger picture of the schedule, allowing the project manager and superintendent a guide as to how far ahead or behind schedule the project is. All construction projects have field managers, such as project managers, superintendents, expediters, and foremen. To ensure that the project agreements, plans, and specifications are adhered to, the project management organization must be precisely defined. Let's discuss the main responsibilities of each. Architect. The architect is responsible for the design of the project, inspecting the building to ensure the plans and specifications are being adhered to, clarifying any architectural questions, and certifying the percentage of completed work to the owner. General Contractor. The general contractor is responsible for the means and methods of construction used on the job. The general contractor is also responsible for properly staffing the project to ensure progress and proper controls. Let's review the staffing requirements and their areas of responsibility. Project Management. The project manager is responsible for all phases of the work on the project, including scheduling, time budget, records, and change orders. They interact with subcontractors, architects, suppliers, government agencies, and unions. The project manager has the responsibility of bringing it all together, completing it on time and budget, and ensuring all records are maintained. The project or site superintendent is responsible for all work phases of on-site activities. They direct the work and maintain safety on the project. They also generate daily log reports, which record progress, problems encountered, and solutions, as well as the personnel on the project during that day. This daily log may be used as proof of decisions in the field and should always be written in ink. The project superintendent also coordinates subcontractors, schedules material and equipment, and serves as a liaison between the job site and project manager. The foremen are those with expertise in their areas of production and are responsible for quality control, directly leading their workers for their specific scope of work. Expediter. The expediter is responsible for the availability, delivery, and storage of materials and for tracking material deliveries for both the contractor and the subcontractor. They are also responsible for issuing purchase orders, alerting the contractor of shortages or delays of materials, and alerting the site superintendent of scheduled material drops so adequate storage and security measures can be obtained. Inventory control. Having the proper amount of inventory to maintain progress and yet not an excessive amount is critical to a well-run project. Good inventory control increases net working capital by not overspending. It also reduces time and expenses in handling materials, moving the surplus items from area to area, and reduces the likelihood of theft, an ever-present danger in today's construction environment. Transaction privilege tax. The state of Arizona puts contractors in a different sales tax classification. Contractors do not pay sales tax at the point of purchase for materials. They instead charge the owner of the project a transaction privilege tax, or TPT. The prime contractor, the contractor that has a contract with the owner of the project, totals all of the income physically received, gross revenues, during the month. This amount is reduced by 35% and then multiplied by the total tax rate for the state, county, and city that the project is being built in. The tax money is sent to the Arizona Department of Revenue by the 20th of the following month. Late payments are subject to a 5 to 25% penalty. If the contractor is being paid by another contractor, this is considered to be a subcontract, and subcontractors are not to receive nor pay the TPT taxes. This item needs to be addressed prior to the tendering of a bid proposal. Chapter 14, Financial. As the business owner, you are responsible for the financial health of your business. Money is the lifeblood of your company, and without it, you are dead. Failure to manage the financial side of your business could lead to inadequate cash flow and can result in bankruptcy. Even though you will probably turn your bookkeeping activities over to an accounting firm, you still should be familiar with accounting terms and reports. One of the first decisions you will have to make concerning accounting is how to record expenses and income for your company. Once selected, it cannot be changed without the written approval of the IRS. In accounting, two different systems, cash and accrual, are ways of recording income and expenses. The cash method records income when the money is physically received and records expenses when a payment is made. It is the easiest to maintain, but it will not reflect earnings of the completed projects when payment has not been received. The accrual system recognizes income when it is earned, even if payment has not been received, and recognizes expenses when incurred, whether paid for or not. The accrual system represents a more accurate financial picture of jobs in progress. Balance sheet. The balance sheet is a financial picture at a specific point in time. It shows only 3 items. These are assets, what you own, such as cash, inventory, buildings, and equipment. Liabilities, what you owe, such as suppliers, credit cards, truck payments, etc. And owner's equity, what you're worth, which is the difference between assets and liabilities. Assets equal liabilities plus equity, or you can arrange this formula as liabilities equal assets minus your equity, or your equity equals assets minus liabilities. Thus, if you know any two, you can calculate the other one. Both assets and liabilities are separated into 2 classifications, current and long-term. Current means you would expect to convert an asset into cash within 12 months. Examples would be a checking account, inventory, perhaps to be used on the next project, and accounts receivable, monies that are owed you for completed projects. Long-term assets, also known as fixed assets, are items that you expect to hold on to for more than 12 months. Examples would be a backhoe, trucks, equipment, buildings, office equipment, and land. The same applies to liabilities. Items you will pay off within 12 months are considered current liabilities, such as money owed to suppliers, credit cards, or utility payments. Larger items that will take longer than 12 months to pay off, such as mortgage payments, truck payments, and office equipment, are recognized as fixed or long-term liabilities. Profit and loss statement. The profit and loss statement, also known as the income statement, shows the financial picture over a given period of time. It shows all of the income during that time frame and all of the expenses during that same period of time. You can quickly view the net profit or losses for that period. Gross profit is determined by subtracting the direct costs from the sale amount. Net profit is determined by subtracting the direct cost, project overhead cost, and the general and administrative cost from the sale amount. Liquidity ratios. Liquidity ratios show the company's ability to pay its obligations for the coming year. It is calculated by dividing the assets by the liabilities. Current ratio divides current assets, which include cash, savings, checking accounts, accounts receivable, and inventory, by the current liabilities, consisting of account payables, lease payments, etc. in which $2 of assets and $1 of liabilities would reflect a 2-to-1 ratio. Operating cycle. The period of time that it takes from the purchase of materials and the start of labor for a project through completion of the project and final payment for that particular project is known as an operating cycle. Chapter 15, Registrar of Contractors. The Registrar of Contractors is the Arizona State Division that has the responsibility of issuing licenses to contractors, as well as enforcement of the rules and statutes pertaining to the conduct and workmanship of contractors. You, as the qualifying party, are the person responsible to ensure the company is building per codes, adhering to the plans and specifications, observing the rules and regulations of the state. You are the person that the Registrar of Contractors views as the competent person of the company. Although you are the qualifying party, the license is not issued to you. It is always issued to the entity. If the company decides to change the entity that they are operating under, they must refile an application for a new license at the Registrar of Contractors. If you, the qualifying party, are an employee of the company and you leave that employment, the license does not go with you. You are also required to notify the Registrar of Contractors within 15 days that you are no longer that company's qualifying party. The company must now replace the qualifying party vacancy within a 60-day grace period of time. Failure to do so will result in the license being suspended. A person can be the qualifying party for a maximum of 2 companies, but only if there is a 25% common ownership. Common ownership means both companies have to have a common link of ownership that amounts to 25% or more. A person is not required to have ownership in a company to be the qualifying party. The license application, once received by the Registrar of Contractors, is reviewed to ensure the applicant is qualified to hold a license. It now enters the posting period, a 20-day time frame when the public is notified that the company's owners and qualifying party has applied for a contractor's license. The public then has a 20-day opportunity to notify the Registrar of Contractors of any issues that may have occurred that may disqualify any of the owners or qualifying party. These comments will be investigated and a determination as to the issuance of a license. The Registrar of Contractors has a 60-day time frame to approve or reject an application. The license is issued for a 2-year period. The Registrar of Contractors will mail a renewal notice during the last month of the active period. The renewal form and fees must be received by the end of the month or the license will be suspended for lack of renewal fee. The license can be reinstated any time during the next 12 months by paying the fee plus a penalty fee. If the license is not renewed within the 12-month period, it will be revoked and not subject to reinstatement. A new application, along with the appropriate fees and bonds, must be made to the Registrar of Contractors and a new license number will be issued. When a license is issued to a company, all contracting businesses must use the company name exactly as on the issued license. The contractor must warranty their work for a 2-year period. Anytime a mailing address is changed, the Registrar of Contractors must be notified of the new address within 30 days. Failure to do so could result in the license being suspended. If there is a change of ownership of 50% or greater, the Registrar of Contractors must be notified immediately. The contractor's license number is required to appear on all advertising, job sites, and other business forms with the initials ROC preceding the license number. Inactive license. A contractor may request that a license be inactivated for a period not to exceed 5 years. A license may not be inactivated more than 2 times. During the time of inactivity, no license bond is required. At any time during the 5 years, the license can be reactivated by the payment of fees and a written request to the Registrar of Contractors. This process takes about 30 days. Citations. If a client is not satisfied with the project you have completed and you cannot or will not correct it to the client's satisfaction, the client can file a complaint at the Registrar of Contractors' office. The registrar will send out a citation notice to you asking if there is any reason that they should not suspend or revoke your license. You then have 10 days to respond to the citation, requesting a hearing. The 10-day period begins 5 days after the postmark of the citation mail date. If the registrar reviews the complaint and finds there is cause, you will be directed to repair or replace the issue in question. The complaint, once validated, will remain on your record for 2 years. If you fail to respond to the complaint, your license will be suspended or revoked, depending on the severity. If a license is revoked, no application for a new license can be made within 1 year. Citations also include deceptive advertising, abandoning a project without legal reason, and failing to complete the project for the contracted amount. Recovery Fund. The Recovery Fund is governed by the Registrar of Contractors and was put in place to assist residential clients who were financially injured by a licensed residential contractor. Only residential clients can access the fund, and only if they used a then currently licensed residential contractor. The process goes like this. A complaint is filed with the Registrar of Contractors, who verifies the validity of the complaint. A citation is issued, and if that does not result in the complaint being resolved, the client is directed to place a claim against the license bond. If the license bond payout does not cover the financial injuries, then they can access the fund. The fund will pay out up to a maximum of $30,000 per homeowner. The Recovery Fund will continue to pay out until a maximum of $200,000 has been paid per contractor. When any payout has occurred, the offending contractor's license will be immediately suspended and restitution will be sought to include accumulated interest. Every residential contractor must participate, which means they will pay, at the time of license renewal, the prevailing fee for the Recovery Fund. The state legislature has authorized a maximum amount, $300 per year, that may be charged to each contractor. Since licenses are renewed every 2 years, the biennial fee could be as much as $600. A contractor may also participate in the Recovery Fund by posting a consumer bond in the amount of $200,000. Most contractors choose the biennial fees. The fund is audited and must maintain a minimum balance of $2 million. Chapter 16, Lien Laws. A simple legal means of collecting monies owed the contractor, subcontractors, and material suppliers are through the lien process. First, let me explain exactly what a lien is. It is a claim on the property for a just debt. In other words, a lien is placed on the property, allowing it to be foreclosed on and sold. The owner may avoid the foreclosure by paying the debt prior to the sale of the property. If not, then the money from the sale is then used to pay the amount owed. Once a lien has been placed on a piece of property, it serves as a cloud on the title, thereby making it difficult to transfer ownership of the property until the lien is removed. The lien process is both time-sensitive and step-sensitive. Pre-liens, liens, notifications of liens must be performed within the time allotted, and each step of the process must be adhered to. If you do not complete the actions within the time allowed, or you miss a step, you can be disqualified from the lien methods of collection. The lien is a legal document, and all information on the lien must be accurate to ensure that it will not be set aside. The legal description of the property must be correct, and information about the legal description should be obtained from a title company, the county records office, or you should employ a lien processing company to handle the whole lien process from preliminary 20 days notice to lawsuit. When choosing a lien processing company, make certain that they have errors and omission insurance to ensure that a mistake on their part will not exclude you from recovering your financial injuries. Here's how the lien process works. Any person that wants the right to file a future claim must send a Form ML6, preliminary 20-day notice, to the project's owner to preserve their right to lien. It must be done within 20 days of your company starting the project. The start of the job is when the company's materials or labor is first on the project. Service of the pre-lien should be delivered by a certified mail or otherwise verifiable means. Include with the ML6 preliminary 20-day notice should be a ML7 verification and acknowledgement of the preliminary 20-day notice. This ML7 form places the burden on the owner to review and notify the sender of any inaccuracies in the preliminary 20-day notice received. The owner must furnish the correct information within 10 days or be prevented from using any wrong information as a defense against a lien. If payment is not made by the end of the project, the contractor has 120 days to file a claim at the county records office in the county where the project is located. The end of the job is noted to be 30 days after the permanent certificate of occupancy was issued by the local building authority, or 60 days of no project activity, or, if no permit was required, then the last day of labor or materials on the project. If the owner files a notice of completion of the project, it reduces the maximum days to file a claim from 120 to 60 days. Notification of this action must be sent to all contractors that have bid on the project, informing them that the lien process has changed. This action is typically done to reduce the time frame that the bank has to pay the owner for the completion of the project. If payment is still not received, a lien must be filed within the 60 to 120-day time period that applies to you. The lien is valid for 6 months. Sometimes during this 6-month period, if payment is not received, you must file a lawsuit to sell the property at a lien sale. You do not need to wait the full 6 months before foreclosing on the property. Contractors who are entitled to a lien are those that have a contract with the owner of the property. These would normally include the general contractor and primary material suppliers. Not only the labor and material costs will be paid, but also lien claimants shall be entitled to recover a reasonable attorney's fee. If the owner needs to transfer the title of the project while the lien is in effect, a release of lien bond can be purchased for the value of the disputed amount, which will allow the owner and the contractor to arrive at an agreement. A claim can then be placed on the bond within 1 year by the contractor. Chapter 17, Safety. The Arizona Department of Occupational Safety and Health Act establish and monitor workplace safety and health concerns. This division can conduct unannounced safety inspections of work sites. It can enforce safety rules, and a contractor that violates the rules and regulations can receive stiff fines. There are several types of violations. The most blatant is a criminal or willful violation that may cause the death of an employee. A contractor can receive a minimum fine of $5,000 to a maximum of $70,000 per incident, and perhaps found guilty of a Class 5 felony. A serious violation is a violation that could result in a serious injury or death. The fine could be from $5,000 to $70,000 per incident. A non-serious violation is a violation where an employee could be injured but probably not result in death. The violator may be fined up to $7,000. A violation that could not result in an injury or death is known as a de minimis violation, which is typically a paperwork violation. This may result from the absence of warning signs or improper record keeping. OSHA has specific wording that determines the adherence to rules and regulations. Shall indicates that it is mandatory. May allows a choice to adhere to or not. All employers are required to adhere to OSHA safety rules, but employers with 10 or less employees are exempt from the record-keeping requirements. If your company has more than 10 employees, in other words, 11 employees or more, then all records of injuries must be kept for 5 years. In the event of a job-related death or 3 or more employees being injured, OSHA must be notified within 8 hours. All injuries, other than those that only require first aid, must have the appropriate record written and kept for the 5-year period. They are not merely sent to OSHA, but kept at your office for inspection purposes. An employer has a 6-day period to complete all paperwork related to an injury. If record keeping is required for your company, every year the company must complete a summary of all injuries that occurred in the preceding year and must post that form in a visible area for their employees to see for a 90-day period beginning February 1st through April 30th. An employee that observes an unsafe workplace and makes a complaint about the safety of the workplace may not be discriminated against. If the employee feels that they have been discriminated against because of such a complaint, that employee shall report such discrimination to the Industrial Commission within a 30-day period from the time of the discrimination. If the discrimination was not reported within this time frame, the report will not be received. The employer has the responsibility of training his employees if they may be working in a hazardous work site. The employer shall also furnish any necessary protective clothing and respiratory protection, training to observe a hazardous area, protection methods for labeling of hazardous materials, and to furnish material safety data sheets describing the type of hazardous chemical being used, the antidote, and other safety directions. These information sheets shall be kept in a location accessible to the employees, such as the prime workplace. All labeling of hazardous chemicals shall be labeled in English, and any corrections to the labels must be completed within 3 months of manufacturer's notification. A written hazard communication program must provide the employees a list of all hazardous chemicals known to be present and the manufacturer's name, address, and phone number of these chemicals. Utility protection. A contractor is required to locate all underground utilities before any excavation. Failure to do so can result in a $5,000 fine plus damages. If you expose any underground utilities, Arizona state laws require you to notify the utility company and allow for an inspection before backfilling. The contractor is not permitted to make repairs. A request to the Blue Stakes Center for locating underground utilities must be made 2 days prior to excavation. Colored markings are used to notate the type of utility. Red is used to denote electrical lines, yellow for gas, blue for potable water, orange for communication cables, and green for sewer lines. Arizona environmental laws. The United States Environmental Protection Agency, or the EPA, a federal agency, protects human health and safeguards the natural environment. To enforce EPA rules and regulations, Arizona created the Arizona Department of Environmental Quality, or ADEQ, to administer state environmental protection laws and a number of federally delegated programs, such as the Clean Air Act program, the Safe Drinking Water Act program, the National Pollutant Discharge Elimination System program, and the Resource Conservation and Recovery Act program. 4 divisions, air quality, water quality, tank programs, and waste programs, carry out ADEQ's core responsibilities. They will provide services for compliance with environmental regulations at no charge. The EPA considers the dust from construction sites to be a major source of air pollution. ADEQ requires a dust control permit for all construction in Maricopa County that will disturb 1/10 of an acre or greater. A dust control plan is required to describe the methods to be used for dust control. The Clean Water Act prohibits the discharge of any pollutants into any navigable waters of the United States unless allowed by a National Pollutant Discharge Elimination System permit. Water runoff from construction sites are considerably more polluting than runoff from agricultural or forest lands. Contractors performing land clearing operation on projects of 5 or more acres are governed by the Clean Water Act Phase 1. Later, changes were made that included small construction activity. Site activities disturbing 1 to 5 acres are now included under the Clean Water Act Phase 2. Even smaller properties fall under Phase 2 regulations if it is determined that there is a significant potential for contribution of pollutants to waters of the United States. ADEQ is also responsible for the Tank Programs Division that protects public health and the environment by preventing contaminating substance releases and reducing the risk associated with contaminated sites. The underground storage tank is defined as having 10% or more of its capacity beneath the ground surface. Failure to follow environmental regulations and allowing polluting substances to enter the air or ground can result in being fined for harm done to the environment, having to pay for cleanup costs, and loss of your contracting license. This concludes the Business Management Review. This is the first of several steps needed in establishing your contracting company. Thank you for choosing the Arizona Contractor License Center for your exam prep, licensing, and business needs. A customer service representative will now assist you with the next step of this process.